Surely you know if you are married or not, but with customary marriages, it's not as clear-cut. Or is it? Hi, I'm Simon Dippenau and I'm a family lawyer. Most couples know if they are married. There was a wedding at a church or a wedding venue, or they visited their local department of home affairs for the simple ceremony. There should be no doubt about their marital status. However, I once had a client who was sure he was not married to his girlfriend, while she maintained they were married in terms of the Recognition of Customary Marriages Act. This law recognizes the validity of African customary marriages, provided certain requirements are met. How did this misunderstanding come about? The relationship turned sour after the couple had lived together in his flat for a number of years. He decided to break it off and asked her to leave the flat. She refused, and he brought eviction proceedings against her. She opposed the eviction on the grounds that they had been married in accordance with Xhosa custom. She then proceeded to the High Court to apply for an order declaring their relationship a valid marriage in terms of Section 3 of the Recognition of Customary Marriages Act. According to the Act, for the marriage to be valid, the prospective spouses must both have been above the age of 18 at the time of marriage and must have consented to the marriage to each other under customary law. The marriage must have been negotiated and entered into or celebrated in accordance with customary law. In this case, the woman was unable to prove that the marriage had been negotiated and entered into in this way. Therefore, she was not entitled to gain financially from the breakdown of the relationship. Was she genuinely mistaken, or was she trying her luck? We'll never know. But customary marriages are not casual undertakings. They are legitimate marriages, and parties married in terms of customary law must register the marriage with the RCMA registration officer within 3 months of the date of the marriage. This removes any uncertainty about its validity. The couple could have avoided this scenario very easily by having a cohabitation agreement in place. Many people believe that if a couple lives together for a particular length of time, marital rights apply, sometimes called common law marriage, but there is no such thing as a common law marriage. A cohabitation agreement, however, is a relatively simple contract that includes details of a couple's assets, property, and the financial contributions each partner makes to the joint home. It's valid when ratified by an appointed lawyer. If this couple had a cohabitation agreement in place, the woman may have been entitled to a share of assets when the relationship ended, regardless of marital status. If you are in a customary marriage and are uncertain about its validity or have any questions about it, give me a call. I can also help you draw up a cohabitation agreement. You can reach me on 086 099 5146 for a confidential discussion.